Mum, I've gone through the case management form with Miss Rogers, and we've identified the issues and those witnesses who are required to give evidence at the trial.
Could I see the form, please? Thank you. Yes, Miss Rogers, please remain seated. In view of the fact that you are unrepresented, it's very important that the court should assist you in completing this form. And essentially, all criminal cases in this court are governed by a set of rules which both the court and all of the parties, and that includes yourself, have to comply with. And the court has to make sure that all matters that may be relevant at the future trial are properly discussed at this first hearing. And really the form's just a way of achieving that aim. So, for example, if there's evidence that's not in dispute, then it may not be necessary for certain witnesses to be called or even for certain statements to be read. So would you be happy for me to go through the form with you to make sure that it's correctly completed?
I did take some advice from a solicitor, and he simply said that I needn't say anything about my defence in the form and that I should say that I deny the offence and I wish the prosecution to prove the case against me.
Yes, I see that you've put that at part 8.4 of the form, and of course there is nothing to prevent you simply saying that you want to put the prosecution to proof. But you need to understand that if you do so, that would prevent you from putting forward a specific defence at your trial, because the rules that I mentioned earlier require that the real issues, in other words, what's actually going to be raised at the trial, have to be mentioned at this stage. Now, I note on the form that, the papers rather, that the summary of your police interview indicates that you told the police officers that you were working on a new house and that you'd been cutting carpets and that you had the Stanley knife in your pocket because of that. Is that something you'd want to tell the court at your trial? Well, it's the truth, so yes, I would like to say that. OK, well, do you agree that maybe we should change part 8.4 of the form to show that that's the statutory defence, that you had the item with you for work that you're raising, rather than simply saying that you want to put the prosecution to proof?
Yes, thank you, ma'am, that would be good.
OK, well, we can come back to that a bit later if necessary, but perhaps if I could just go through a couple of other aspects of the form with you. For example, in part 4, you haven't recorded either your phone number or your email.
Yeah, well, I don't want the police bothering me.
OK. But would you have any objection, for example, to either the court or the prosecution contacting you solely in relation to this case? It might be, for example, if the hearing date has to be changed at short notice or something urgent crops up in the case, you can be contacted quickly rather than waiting for a letter through the post.
Yeah, I can see that. OK, I'll put my mobile number and my email on the form when you've finished with it.
Thank you. That's very helpful. Just a very brief word about part 6 of the form. Now, obviously, I understand the defence that you're wanting to raise, and I'm not trying to persuade you against that. But I do need to just ensure that you understand about credit for pleading guilty.
Well, to be honest, Mum, I've been in court before and I know about getting a third off for a quick guilty plea and getting nothing knocked off if I go not guilty and get convicted at the trial. But I'm definitely pleading not guilty to this. OK, no,
that's fine. I just need to note on the form that you understand that. And I just also need to ensure that you understand that if the matter goes to trial, the prosecution costs are inevitably going to be much higher. And if you are convicted after trial, then you may be ordered to pay all or part of those costs. Do you understand that also?
Yes, I do understand that.
OK. Well, ordinarily, at this point, I would explain at the end of the hearing what would happen if you didn't attend court for trial. But for the sake of the form, if I could just clarify that now. If you don't attend at your trial and if the court either doesn't have an explanation from you at all or the explanation doesn't provide a good reason for your non-attendance, then it's most likely that the trial will go ahead in your absence. And what that means is that the court's only going to hear one side of the case and there wouldn't be the opportunity for the court to hear the defence that you wish to put forward. Do you understand that also?
Yes, ma'am.
OK. I note that otherwise all the boxes are ticked in 8.1. And that all seems to be fine, except for the interview, which I note doesn't appear to be agreed. Is there something in the summary you're unhappy with?
Well, Mum, it just seems so short, and I must have been in that interview room for at least 45 minutes. And I gave all the details to the officer about where I've been working and for how long and all that sort of thing.
I understand that, Ms Rogers. I think the important thing is that the summary does cover the part of the interview where you tell the officer that you had the knife for work, which is the defence that you're putting forward. Any other information about where you were working and so forth can form part of the evidence that you give at the trial. We don't necessarily need to know everything that you told the officer in interview.
Will I be able to ask one of my workmates to come to the court to tell you where I was working that evening?
Yes, of course, and it's very important that you do make sure that any witnesses that can assist your case come to court and are available on the trial date. You don't have to give the court details of those witnesses at this stage. You just need to say how many witnesses you're calling and make sure they know about the trial date. But in due course, you will need to provide their details. That's their names, their addresses and their dates of birth. Now, there is a particular form that deals with this, but as you're unrepresented, if it's easier for you, you can simply send a letter into the court and the prosecution, either by first-class post or delivering it by hand, setting out those details. And I'll deal at the end of the hearing with the timescale in which you need to do that once I've discussed with the prosecution their obligations.
Well, in that case, I'm happy to agree with the summary of the interview as it stands.
Thank you, Ms Rogers. Just lastly, in order to prevent the trial taking longer than is necessary, there is a way of putting before the court all matters that are agreed in a written form. And what I'd like you and the prosecutor to confirm is that the basic facts in this case can be agreed. In other words, when and where you were stopped, what time it was, the fact that you produced the Stanley knife to the police officer, and the fact that you were properly arrested and taken to the police station. Can all of that be agreed?
Yeah, that's all fine with me.
Well, thank you, Miss Rogers. And so, in view of that agreement, I suspect there's no need for the Crown to call PC Smith, although I see again that you and the prosecutor have said that his evidence can't be agreed.
Well, that's because PC Smith does know me, and he said some unpleasant things about me when I told him why I had the knife.
Well, Mr Hucknall, presumably you've got no objection to editing his statement to exclude any irrelevant or admissible matters?
Not at all, Mum.
Well, then, Miss Rogers, if the statement of PC Smith merely deals with the undisputed matters which we've discussed, then we don't really need him to come and give evidence at court, do we?
No, ma'am, that suits me fine.